Good morning.
Hey, good morning, everyone. We'll go on the record now in Lee versus Lee. This is file number 2419864. If I could have counsel for both sides put your appearances on.
Yes, good morning, Your Honor. This is Matt Motley appearing on behalf of the plaintiff.
Good morning, Judge Elliott Blumberg, on behalf of the defendant, who's actually in my waiting room. Can I just wait a moment to bring him in?
Sure, absolutely.
Thank you, Judge. He's now in my office.
Okay. All right, the record should reflect Ms. Lee is also connected by Zoom video. This is set as a status conference in this file today. Mr. Motley, on behalf of plaintiff, can you tell me where things are at? I think this is your first appearance on the record anyway for Ms. Lee. So can you tell me from your standpoint where things are at and what we need to do for scheduling going forward?
Change the scheduling. I mean, I'll just start by saying I think 90 days of discovery would be sufficient. I know we still have that pending hearing with the friend of the court coming in September for the issues relating to custody, parenting time, and child support. So if nothing gets settled before then, I anticipate that hearing would resolve those matters. But either way, I think 90 days of discovery would be sufficient, giving us maybe 120 days to mediate. I'm confident that we can select one in advance of that. So I think that as be a starter here is just getting these next steps done.
Thank you, Mr. Blumberg.
Judge, while I don't disagree with counsel's request in terms of discovering and scheduling, there is an ongoing violation of your court order. Ms. Lee continues, in spite of your order, to deny my client parenting time. We continue to file complaints with the friend of the court, but hearings aren't scheduled out until September or later. I think you'll remember that Ms. Lee was represented by prior counsel. We had most of the day to come to an agreement. There was a signed agreement prepared. Ms. Lee fired her attorney and then refused to sign the order. You subsequently signed that order, but she continues to ignore it, and my client does not have the opportunity to see his kids. So if you want to know the status of the case, that's a major problem right now.
Okay. Mr. Motley, have you discussed that issue with your client?
We have, and I mean, we more or less filed an objection. I mean, again, without getting into the substance of what this is, what the agreement or the alleged agreement happened. Obviously, I think we have a different position on this. I'm understanding that there's a hearing set in mid-September to address these issues. Otherwise, I think the parenting time's been going on schedule, but I think the major point was the no contact order due to the pending criminal sexual conduct case against the defendant here, that he's not supposed to be at these pickups, which I thought was a major term of the agreement. That again, I talked to her attorney. I don't know the all the substance of the agreement, but I know if the parenting time schedule that was in place is supposed to be in place, that he was not to be doing these pickups and drop offs just by virtue of the no contact order that's there. And it's my understanding that he's been going to these. That is one piece of it, but again, I don't want to get into the substance of that today.
All right. Well, I mean, that's an issue that's going to have to play itself out, according to the normal procedures of the court. I guess I would just say, there is an order in place, Mr. Motley, to the extent your client is not following that. And you guys, everybody's going to have a chance to argue about whether that order should stay in place or not based on what happened previously. But the fact is, there is a court order in place. And to the extent that your client is just willfully violating that because she doesn't agree with the way that order got entered, that's not a reason to just not comply with the order. So all I would say is, to the extent that she's found to be failing to comply with that order, and not having any legally justifiable reason for doing so, I just think you need to caution your client that the court, I would fully intend to use the full weight of the court's contempt sanctions to compel her to follow that order if it's not changed, and she needs to be following it now. And to the extent, Mr. Blumberg, that your client is doing something that's in violation of that order, that only hurts your client in terms of his ability to have that enforced. So I think both sides need to follow the order to the extent that either the referee or the court or both find that neither side has appropriately followed it or either haven't. I am not going to tolerate from either of these individuals, Mr. Lee or Miss Lee, just ignoring the court's order. In particular, in this case, I think the court needs to take a hard line with both of these individuals because I think they both just want to do what they want to do, and that's just not going to happen. The court's orders mean something, and to the extent that either side isn't following them, both Mr. Lee and Miss Lee need to be prepared to pay the price for that once that's determined. So that's all I'll say with regard to that. This is a status conference. This isn't an evidentiary hearing. I'm not going to make any findings on that, but I just want both counsel to caution your clients that I'm just not going to tolerate it in this case. And again, in particular, based on the evidence that I've heard so far as to the actions of both parties. So that being said, I do think, and there was no objection to it, I do think Mr. Motley's suggestion in terms of scheduling is appropriate. So the court will enter that in terms of a scheduling order. 90 days for discovery, mediation to occur within 120. The court will set this for another status conference at that point. Otherwise, the parties will proceed in front of the court, and to the extent there are objections to the front of the court rulings, we'll get those scheduled in due course as well. Mr. Motley, is there anything else that I can address for your side today?
I mean, there are minor stuff like the witness list and exhibit list, but I assume the court's just going to outline that in the scheduling order that's going to result from today's hearing.
Well, yeah, I mean, if we need to, this is going to get us going up through mediation. If there aren't any agreements, then we'll set additional dates for court hearings, and we'll schedule those types of matters in with that.
Yeah, that's all I had, Your Honor.
Okay, Mr. Blumberg, anything further from your side today?
No, Judge, thank you. I appreciate you addressing my concerns. Thank you.
All right, thank you. That's all for today. All parties on this file are free to disconnect. And Mr. Blumberg, I'm just going to put you on hold for a minute. I know you have the other 9 o'clock hearing as well.
I do. Thank you.
Thank you, Your Honor.
You want to hear around for a while?
All right, we'll go on the record in Meyer versus Meyer. This is file number 2419940. If I could have counsel put your appearances on, please.
Good morning, Judge Elliott Blumberg on behalf of the plaintiff.
Good morning, Your Honor. Travis Grote on behalf of the defendant.
You were on the record here today for a status conference in this matter. We set some scheduling dates back in February, which I think was the last hearing before the court. Mr. Blumberg, on behalf of plaintiff, can you tell me the status?
Yes, Judge. I think the parties have come to an agreement, certainly on the issues of custody and parenting time and support. the property issues are very close to being resolved, so I think we can report to the court that we're very close to an agreement in this matter.
Okay, Mr. Grove?
I would agree, Your Honor.
All right. If I set this for a final hearing in 30 days, is that enough time to be ready to enter the judgment, Mr. Plumber?
I believe it is.
Okay, Mr. Grove?
Yes, Your Honor, that would be fine.
Okay, Mr. Blumberg, anything else I can address for your side on this file today?
I don't think so, Judge. Thank you.
Mr. Grove?
No, Your Honor, thank you very much.
Okay, so I'll set this for a final hearing in about 30 days. The court will send out notice of the date and time of that hearing to counsel and the parties, and all parties on this file are free to disconnect at this time. And Mr. Blumberg, I think you have the 9:15 as well, so if you just want to remain connected, and we'll get that started in just a second.
Great. Thank you.
Ma'am, if you could unmute, please.
Okay,
There we go. Hi, can you tell me your name?
Karen Howe.
Okay, Ms. Howe, sounds good. 1 second. Okay, we'll go on the record in Howe versus Howe. This is file number 2520107. Mr. Blumberg, you're appearing on behalf of Mr. Howe, is that correct?
Yes, Judge, he's in my waiting room. If you can give me a moment, I'll get him in here. Thank you.
Sure.
Okay, thank you, Judge. Mr. Howe is in my office now. Thanks.
All right, and the record should reflect Ms. Howe is connected by Zoom video. This is a first hearing before the court for scheduling. Mr. Blumberg, can you tell me from your client standpoint the status of this case?
Judge, I think both parties have now completed their domestic relations financial forms. I think other than perhaps some brief discovery, the parties are in a position to either sit down and discuss a settlement or to go to mediation. I would hope that, and I think Ms. Howe would agree, for the three of us to sit down and discuss a potential resolution to all issues. We're certainly not opposed to that.
Okay, and Mr. Blumberg, is a 60-day period. Do you think that would be enough time?
I do, yes.
All right, so Ms. Howe, what I would do is set this for, give the parties about 60 days. I would refer this to community mediation. Do you know what that is?
No,
Okay, so community mediation is where you and Mr. Howe and Mr. Blumberg would sit down with the neutral third party. And when I say sit down, I mean virtually. It would be by Zoom like we're doing today. But you would meet with a neutral third party who's a trained mediator. They would attempt to help you and Mr. Howe to reach agreements as to how to divide up assets and debts. You're not required and nobody's forced to reach any agreements, but they try to facilitate that through that process. If you're able to reach an agreement, then that would resolve everything and we would have one final hearing to finalize the divorce. If you're not able to resolve everything, then we would discuss how to go forward to get those things resolved. Do you have any questions about that?
No, that sounds good.
Okay, so you don't have any objection to doing that?
No, no, I think
Okay.
we can.
Okay, so the court will have discovery remain open for the next 60 days. The court will refer this to community mediation to occur within that 60 days. Obviously, Mr. Blumberg, if you and your client want to have informal discussions with Ms. Howe to see if you can agree on things prior to mediation, that's fine as well. And then I'll set this for a status conference at 60 days. If things have been resolved, then we can use that date to finalize the divorce. And if not, then we'll discuss how to proceed. Any other things I can address for your side, Mr. Blumberg?
No, Judge, thank you very much.
Ms. Howe, do you have any questions about how we're gonna go forward?
No,
Okay. So that's all for today, and both sides are free to disconnect on this file. And again, Mr. Blumberg, I see you have 9:30, so if you just want to remain connected, I'll bring you in when that case is up.
Great, thank you.
so we're done.
Yes, you're free to disconnect. Thank you.
Don't even know how to.
Should be something that says end.
Nothing.
Oh, this is that one.
Yeah.
Okay, we'll go on the record in Purcell versus Purcell. This is file number 2419939. We have counsel connected. If I could have counsel put your appearances on, starting with plaintiff.
Good morning, Your Honor. Brooke Robinson appearing on behalf of Kendall Crussell, who is sitting to my right, both appearing via Zoom.
Good morning again, Judge Elliott Blumberg on behalf of the defendant.
Thank you. This is set for a status conference today. Ms. Robinson, on behalf of plaintiff, can you tell me where things stand in this file?
Yes, Judge. Initially the parties came to us. They had an agreement of how they wanted things divided, how custody would be set up. Somewhere along the way, I think there had been a breakdown of that agreement. Defendant has now sought independent counsel. We are we've put together our financial disclosures and everything, but we haven't had any disclosure from defendant, and we believe defendant has some issues of contention now as far as a valuation of the business and how property is divided. So I think today, Your Honor, as far as the status, we might need to adjourn the status conference and ask for perhaps even a scheduling order to open discovery and order for mediation going forward so that we can come to some sort of resolution here.
Ms. Robinson, do you have any suggestion for the timeframes on that?
Do you think we would be able to open discovery for at least the next 60 days and possibly attend mediation within 90?
Okay, thank you. Mr. Blumberg?
Well, I think most of what counsel's represented is accurate. The parties had a post-nuptial agreement drafted by Mr. Crussell, which later became the basis of an agreement on custody and property. It was certainly my view. I've only been involved in the case for a short time now, but certainly my review found that that agreement was not fair and equitable. There was no compliance with the law as it relates to post-nuptial agreements. So all of the issues are really back on the table, and I think 60 days is an appropriate amount of time to do the discovery necessary. So I think that the schedule asked for by plaintiff's counsel is appropriate.
Okay, one other question. It sounds like there's a business involved. Ms. Robinson, do you think community mediation is appropriate, or do you think that you're going to need an attorney mediator?
I think we can work with community mediation on this.
Okay, Mr. Blumberg?
Well, it's a fairly new business. We can certainly try that.
Okay. Okay, so we'll have discovery remain open for the next 60 days. The court will order that mediation through community mediation occur within 90, and then I'll set this for a status conference at that time. Ms. Robinson, any other scheduling dates I can address for your side today?
No, Your Honor, thank you.
Mr. Blumberg, any other matters I can address for your side today?
Judge, I would ask only that if the parties needed to extend discovery for a short period, we could do so by stipulation rather than having to file a motion.
That would be fine with me, and yeah, if 60 days turns out to not be enough, given the assets, that I don't have an issue with that at all.
Other than that, I have no other questions or issues.
Okay, thank you. I will put that into an order and get that out to the parties along with the notice of the date and time for that next status conference. And all parties on this case are free to disconnect.
Thank you.
Thank you.
All right, the court calls the matter of McGovern versus Zasadny. That is file number 2419592. That was set for a hearing today. Just want to make sure. stating things correctly for the record. So back in May, the court directed the plaintiff to enter a final order, present a final order. That has not occurred. We had a hearing in July. Neither party appeared for that hearing. And this hearing was set for 9:30 here today. It's now 9:37. Neither party has appeared. Ms. Blaine, did you have any kind of update on this?
No, sir, we haven't had any contact with either party. I've been unable to reach either of them recently. And just for the record, this has been ongoing since the end of October, where we've been trying to get this final order.
Okay, so even longer than May then. All right, based on the current status of the case, the efforts the court is making to get this resolved, the lack of any participation, at least since May, and it sounds like longer than that, by either party, the court will dismiss this matter, and I'll enter that order to dismiss today. So our next hearing is at 9:45. Will be in recess until that time.
dive into another one.
Okay, we're on the record in Vander Kirchhoff versus Vander Kirchhoff. This is file number 2419800. If I could have counsel put your appearances on, please.
Reagan Richards, Legal Services of Northern Michigan, on behalf of plaintiff Haley Van Diekerchove, who is seated to my right in my office.
Good morning again, Judge Elliott Blumberg on behalf of Nicholas Vanderkachove, who's appearing via Zoom from my office.
Okay, and then the record should reflect that we have Luke Vander Kirchhoff also present by Zoom video. This is set pursuant to your motion today. Ms. Richards, I did have a chance to review your motion and the proposed order. What would you like to say today in support of your motion?
Your Honor, we are just asking the court to order that Penelope Van Diekerchove is a child born not of the marriage. The alleged father is Mr. Luke Van Diekerchove. He is willing to pursue paternity if the court does order that, and all parties all parties have held out that the child is not born of the marriage since conception.
Thank you. Mr. Blumberg, do you have an objection to the motion?
No, Judge, I think everybody acknowledges that my client, the husband, is not the father of this child.
All right. Mr. Luke Vander Kirchhoff, have you been able to hear what was said so far?
Yes, sir.
Do you have any objection to the court entering this order today?
No, Your Honor.
Okay. So the court will grant the motion. I will sign that order as proposed by Ms. Richards. Mr. Blumberg, have you had a chance to review that proposed order?
We have, Judge.
Do you have any objection to the form?
No, I do not.
Okay. All right. So the court will sign that order. Ms. Richards, anything else that I can address for your side today?
No, Your Honor, thank you.
Mr. Blumberg?
No, Judge, thanks.
Okay. Thank you. All parties on this file are free to disconnect at this time.
Thank you, Your Honor.
All right, Mr. Heller, are you able to hear me okay?
I am, Your Honor. Can you hear me?
I can, thanks. I'm just trying to see if opposing counsel is connected. The only other party I see is a Stacy Holshoe. Is that somebody who might be appearing on behalf of opposing counsel?
Not that I'm aware of, Your Honor. I'm happy to mute for a moment and at least try to get a hold of plaintiff's office.
Okay, that'd be great. Thank you.
Okay, sure, you bet.
And sir, with the Bobby's iPad, are you
Yep.
connected on the Mixon versus DRC Reynolds case?
No, sir. I'm Robert Holshoe with the divorce case of Robert Holshoe, Stacy Holshoe.
Okay, got it. So you guys are at 10:30, so I'm just gonna put you on hold until 10:30, okay?
Okay.
I mean, I see on the schedule. Oh. Can I see the top of that one?
Your Honor, I spoke with, let's see, Bradley Perry for plaintiff. His understanding is that Nicole McCarthy is either should be here or attempting to get on. So he's, I think, scrambling for a moment to try to get a hold of her.
Okay, sounds good. I'm just gonna put you in the waiting room and then we'll see where we go with this.
Okay, thanks, Judge.
Others. Okay, Ms. McCarthy, are you able to hear me okay?
Yes, good morning, Your Honor.
Okay, good morning. All right, we have everybody connected now, so we'll go on the record in Mixon versus DRC Reynolds. This is file number 2520037. If I could have counsel put your appearances on.
Good morning, Your Honor. Nicole McCarthy appearing on behalf of plaintiff.
Good morning, Your Honor. James Heller for defense.
All right, thank you. We're on the record today for purposes of a scheduling conference in this case today. Ms. McCarthy, I just want to make one disclosure here. I am personal friends with Mr. Heller. We socialize outside of the courtroom context. My wife and his wife have a business relationship in the operation of Pilates and a yoga arrangement.
Okay.
I don't think either of those are extensive enough that I need to disqualify from the case, but I do want to disclose that to you. That's something that you can discuss with your client. If you do feel that there's a basis for disqualification, certainly I'd be open to a motion raising that as an issue. But again, I wanted to disclose that to you here at our first hearing.
Your Honor, I'll discuss that with my client.
Okay, that being said, again, we're on the record here for a status conference. So Ms. McCarthy, in terms of just the claims here, can you just kind of tell me a little bit about what your claims are and what you would like to see for scheduling going forward?
Sure, Your Honor. It's a pretty straightforward trip and fall on a dilapidated porch outside of a property that my client was renting from defendant. She did injure her ankle and subsequently have surgery. She is still treating for that. She's still recovering from that. I don't think it's a particularly complex case. I would think 90 to 120 days would be appropriate, but I'm certainly open if Mr. Heller thinks differently.
Okay, Mr. Heller.
Yeah, thank you, Your Honor, and thank you, Ms. McCarthy. Facts are, as Ms. McCarthy stated, I think, yeah, straightforward. There isn't a lot at issue. I would anticipate for purposes of discovery, at least obviously the deposition of plaintiff and potentially some discussion with a representative from DRC as well. I think the only holdup, the time window, I think is reasonable from Ms. McCarthy. I might suggest closer to 150 days, and that's just for practicality of retrieving, requesting, and reviewing medical records. But I'll leave that to the court's discretion.
All right. I'd rather build in a little extra time for discovery rather than having the parties have to go through the process of a stipulation in order to extend. So we'll set discovery for a period of 150 days. The court will order facilitated mediation within 180 days. Ms. McCarthy, do you believe that you and Mr. Heller will be able to agree on a mediator?
Oh, yeah, absolutely.
Mr. Heller, do you think that will be an issue?
No, Your Honor, thank you.
All right, so I'll just ask the parties to confer and select a mediator and then notify the court of your selection within 30 days, again, with a mediation cutoff of 180 days. Ms. McCarthy, do you have any objection to a dispositive motion cut off 30 days after the close of discovery?
No, Your Honor.
Mr. Heller?
No objection, Your Honor, thank you.
Would that be a heard by date or a filing date?
Filed and heard. Ms. McCarthy, are you anticipating needing to amend pleadings or add parties?
This time, no.
Okay, Mr. Heller?
No anticipated amendment, Your Honor.
Okay. All right, so again, 150 days for discovery with that mediation cut off at 180 days. Dispositive motion cut off 30 days after the close of discovery. And then I will set this for a status conference about that time. If there are motions that have been filed, the court will set the status conference at the same time as the motions. If not, then that would be our next hearing date. If the parties are able to resolve it prior to that, just notify the court and we'll take that date down. All of this will be in a pretrial order, which the court will send out to both of you. Ms. McCarthy, any other scheduling matters I can address for your side today?
Want to ask, Your Honor, does the court do the settlement conference in person, or can we anticipate most things will be Zoom?
Everything will be Zoom unless it requires an evidentiary hearing.
Okay. That's it for me then.
Okay, Mr. Heller, anything else I can address for your side?
No, thank you, Judge.
Okay, all right. Again, that'll go out in an order to both of you, and both sides are free to disconnect at this time.
Thank you.
Thank you. Have a good day.
You too. Take care.
Are you able to hear? Okay.
Yes.
Okay. Mr. Holshoe, are you able to hear me?
Yes, sir.
Okay, great. We're on the record now in Holshoe versus Holshoe. This is file number 2520105. The record should reflect that both parties are connected today by Zoom video. I have this set as a date to enter a final judgment of divorce. Mr. Holshoe, is that how you wanted to proceed?
Yes, sir.
And Ms. Holshoe, is that how you wanted to proceed as well?
Yes.
Okay. If I could have you both raise your right hands, please. Do you both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes, I do.
Thank you. You can lower your hands. I'm going to be asking you both a series of questions. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. Mr. Holshoe, as the filing party, my questions are going to start with you. You filed for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Otsego County for at least 10 days?
Yes, sir.
In the complaint for divorce, there's a statement that indicates that there has been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
Under the proposed judgment of divorce that was submitted to the court, you would not be receiving any alimony or spousal support. You understand be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, sir.
All right, and then there are some additional portions here that were attached to the judgment of divorce regarding the division of some personal property, some debt, a checking account, some vehicles, and then real property. Have you reviewed all of those provisions?
Yes, sir.
And under those provisions with regard to the real property, that this indicates that that is going to be awarded to Ms. Holshoe, is that correct?
Yes, sir.
Are both of your names on the deed to that property?
Yes.
Okay. And are both of your names, is there a mortgage or something securing some debt with regard to that property?
Yep.
And are both your names on that mortgage as well?
Yes, I believe so.
Okay. So as part of the divorce, Ms. Holshoe will keep that real property, and then she's going to have that refinanced in her own name and have your name removed. Is that your understanding?
Yes, sir.
Okay. So I just want to make sure that you understand something, because this sometimes comes up later after a divorce is entered, when the parties are going to divide up property this way, that I cannot force a bank to, refinance the property for Ms. Holshoe. So that's something that, she's either going to be able to do or she's not, based on the bank's qualifications. But if they deny her that, that's not something that I can order them to do, in which case, your name is going to remain on the current mortgage. Do you understand that?
Yes, sir.
Okay. All right. And do you agree to abide by all those conditions in that judgment regarding the division of all the property?
Yes, sir.
Okay. And I have here, it looks like your signature on August 1st of 2025. Is that correct?
Yep.
And by signing that judgment, did that indicate your agreement with it?
Yes, sir.
Okay. Thank you. Ms. Holshoe, have you heard all the questions that I asked Mr. Holshoe?
Yes.
Have you heard all of his answers?
Yes.
And do you have any reason to believe that any of the answers he gave were untrue?
No.
Are you currently pregnant?
Currently pregnant?
Yes.
No.
Under the judgment, again, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that, and you would not be able to come back later and ask the court for that.
Yes, I do.
All right. And you heard me discussing the division of that real property on Farmer Road with Mr. Holshoe.
Yes.
Is that your understanding of how that's going to work as well?
Yes.
And you signed this judgment also on August 1st, is that correct?
That's correct. Yes.
And by signing that judgment, does that mean that you are agreeing to that and willing to abide by the terms in that?
Yes.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the judgment. I find that it's equitable and contains all the provisions required by statute. The court will grant the divorce, and I'm signing that judgment. So your divorce is final as of today. Ms. Holshoe, are you asking to have your last name changed?
Yes.
What would you like that changed to?
Teckel.
Can you spell that for me?
Techel.
Okay. So I'm writing that into the judgment as well. Because the divorce is final as of today, Ms. Holshoe, your last name will be legally changed. So you'll need to make sure that you change your identification and other documentation, okay?
Okay.
Do you have any questions about that at all?
No.
Mr. Holshoe, did you have any questions?
No, sir.
Okay, thank you. That's all for today, and both sides are free to disconnect at this time. Okay, Mr. Plummer, do you have Mr. Van Til with you in your office?
Yes, I do.
Okay, and looks like Ms. Van Til is connected. We'll go on record in Van Til versus Van Til. This is file number 20004. The record should reflect that Ms. Mantel is present today by Zoom video. And Mr. Blumberger is present by video also on behalf of his client who's with him, Mr. Mantel. This is set for entry of a consent judgment of divorce today. Mr. Blumberger, is that how you wanted to proceed?
Yes, Judge, and if you would allow me, maybe I could take the proofs from Ms. Mantel.
Okay. And Ms. Mantel, is that how you wanted to go forward as well?
Yes.
Okay. Can both of you raise your right hands, Mr. Mantel and Ms. Mantel? You both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can both lower your hands. Ms. Mantel, Mr. Blumberger is going to be asking you some questions now. The questions he's going to be asking are those that are required to establish the grounds for divorce under Michigan law. He's going to be asking you the questions because you were the party that filed in this case. Mr. Blumberger, feel free to proceed.
Thank you. Ms. Mantel, can you state your full name for the record, please?
Tammy Sue Vantil.
And you are the plaintiff in this action, isn't that correct?
Yes, sir.
And is it true that on February 24th of 2025, you filed a complaint for divorce in the Otsego County Circuit Court?
Yes.
And in your complaint, you allege that you had been a resident of the state of Michigan for at least 180 days immediately preceding your filing. Was that true?
Yes.
You further allege that you'd been a resident of Otsego County for at least 10 days immediately preceding your filing of your complaint. Is that true?
Yes.
In your complaint, you allege that on July 22nd of 2023, you married Timothy Van Til in Otsego County, Michigan. Is that correct?
Yes.
That ceremony was performed by an individual who was authorized to perform marriages. Isn't that correct?
Yes.
You further alleged in your complaint that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Yes.
And is that true today?
Yes.
You allege further that you are not pregnant. Is that true?
Yes.
Okay. Now, you and Mr. Van Til have come to an agreement on all of the property-related issues in this marriage. Is that not true?
Yes.
Okay. And you believe that the division of assets and debts that were discussed through mediation and resulted in this consent judgment are both fair and equitable?
Yes.
Okay. And that requires Mr. Van Til to pay you a sum of money within, I believe, 14 days of the entry of the judgment. Is that correct?
Yes.
Okay. You understand that neither you or Mr. Van Til are seeking spousal support or alimony, and neither one of you can come back at a later date and ask the court to review that issue. Spousal support's forever barred for both of you. Is that your understanding?
Yes, sir.
Okay. Are you asking the judge to ultimately sign this proposed judgment of divorce, which terminates and dissolves your marriage?
Yes, please.
And if the judge were not to sign this for whatever reason, is there any chance that you and Mr. Van Til would go back to living together as husband and wife?
No.
Thank you. Judge, I think that satisfies the statutory requirements.
Okay, I would agree. Did you want to take any testimony from your client today?
Just briefly. Tim, you participated in a mediation in this matter, is that correct?
Yes, sir.
And as a result of that mediation, you and your wife have come to an agreement on the division of assets in the marriage. Is that also correct?
Yes, sir.
Do you believe that that division is both fair and equitable?
Yes, sir.
Is there any chance of reconciliation in this matter? That is, getting back together with her?
No, sir.
You asking the court to sign this judgment?
Yes, sir.
Okay, thank you.
You're welcome.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the proposed judgment and find that it's equitable and contains all the provisions required by statute. The court will grant the divorce, and I'm signing that judgment with today's date. Mr. Blumberg, anything else I can address for your side?
I don't believe so, Judge. Thanks.
Ms. Van Til, did you have any questions at all?
No, Your Honor.
Okay, so Ms. Van Til, just so you're aware, your divorce is final as of today. And that's all parties are free to disconnect. Oh, yeah, Mr.
I'm
Fuller?
sorry, Judge, there is one matter, and I apologize for not mentioning this. Ms. Van Til, you are seeking the restoration of your maiden name, is that correct?
Yes, sir.
And that is Major, Mager?
Yep. Mager.
Right. And Judge, I have omitted that from the judgment. Would you be adverse to just writing it in your own penmanship?
No, do you have any objection to that, Ms. Van Til?
No, I do not.
Okay. Can you just spell that for me again, Ms. Van Til? Mager, is that correct?
Yes, Your Honor.
Okay, so I've added in a paragraph 18 and handwritten that provision in. So Ms. Van Til, because your divorce is final today, your last name will be legally changed going forward. So you'll need to make sure that you change your identification and other documents, okay?
Okay.
Do you have any questions about that?
No, Your Honor.
Okay. All right, thank you. That's all for today then, and both parties are free to disconnect.
Thanks again, Judge. I appreciate
Thank you.
that.
Okay.
Morning, Your
All
Honor.
right, looks like, good afternoon, or morning, rather. Looks like we have everybody connected, so we'll go on the record now. This is Spartan Sewer and Bergdorf versus Sitz Tax, file number 2419857. If I could have both counsel put your appearances on, please.
Your Honor, Hob Ingleson for Spartan Sewer and for Mr. Bergdorf.
Good morning, Your Honor. Michael Weiss appearing on behalf of defendants Sitz Tax PLLC and G. Michael Sitz.
All right, we're on the record today, Mr. Weiss, for your motion for summary disposition on behalf of Sitz Tax. I did have an opportunity to review your motion and the supporting documents. Mr. Ingleson, I did get your response and the exhibits to that. And then I believe there was also a reply, Mr. Weiss, that you filed. I've also had a chance to review the file generally, including the complaint. So I'm familiar with kind of the factual basis here, as well as the parties' legal arguments. Mr. Weiss, anything that you would like to present today by way of oral argument in support of your motion?
I'll try to keep it. I could probably rest on my brief, but I'll try to keep it real simple, just so on a couple of things I want to point out. First of all, this complaint was filed in July of 2024, over a year ago. It was amended in December of 2024. We mediated, we had discovery, everything's all closed. We're now ready for trial or motions. There's 2 counts, breach of fiduciary duty and conversion. And the complaint simply states very clearly the breach of fiduciary duty is for withdrawing funds from the bank account without authorization and for performing services in excess of reasonable compensation. And the conversion is, again, for taking money without permission. We gave you his admissions where he signed the agreement. The agreement clearly says that we're supposed to take out the money, crystal clearly. And he gave us the bank account information to do that. The engagement letter clearly says $1,500 a week, plus $700 a month, plus $18K, and then plus tax services on page 7. Those items are substantiated. He testified that he thought that $3K, I'm sorry, that it would be double the $3,000 a month, which is $6,000. The contract's actually more than that, but that's what he testified he thought would be reasonable. His engagement letter, he signed it. His signature appears on it. He may not remember, but he said that's his signature. And it authorizes exactly what we did. He knew we were doing it. He never told us to stop. He admitted he had that. He never said there's not a single improper bill identified. There's no evidence anything wasn't authorized. There's nothing saying he didn't sign that agreement because he did. No, anybody. It's barred by the engagement letter. We did exactly what it says to do. No contrary evidence. It's barred by the law. We told you 5 separate cases, including the Michigan Supreme Court, that you can't turn a tort into a contract unless it's separate and distinct from the obligations in the contract. There's 5 cases that say that. Their reply brief doesn't say anything, doesn't challenge that. Since we're allowed to withdraw the money, you cannot make up claims for fiduciary duty and conversion for taking money that the contract says we're allowed to do it. And it's barred by waiver because he clearly admitted that he knew we were taking the money out for the 18 months that this relationship went on after he rehired us, and he never told us to stop at any point in time. We cite case law in support of that. Again, nothing contrary. I really don't have anything more to say. I would have said a lot more, but it does sound like you're familiar with the facts and the law. So I'll reserve any other time I have to respond to anything that Mr. Ingleson says, unless you have any questions, Your Honor.
I don't have any questions. Mr. Ingleson?
Well, I'm in the same position as Mr. Weiss to a large degree, Your Honor. And we obviously oppose this motion. We've submitted the testimony at great length of Mr. Bergdorf's testimony on whether he signed or didn't sign any contracts. The totality of his testimony is, including this particular 2/23/2022 purported contract, looks like his signature, doesn't recall it, denies signing it, and that's why I went to the trouble of giving you all the pages throughout the deposition. We've also indicated there was a 14-year relationship, which was a verbal agreement for
accounting services that got invoiced, got paid. As it turns out, Mr. Bergdorf's recall of what was being paid was far less than he thought in his deposition, was more on the average of 3 or 4 a year and not 3,000 a month. But that's a bit of a side thing here. The complaint discloses the relationship. The complaint, unless I'm completely off the mark, does not deny the right of his access. That was granted. He testified to it. The issue in this case is under an agreement between the two of them, and not the written one. He doesn't have carte blanche to take whatever he wants, as opposed to what had been promised between the two parties. We think the motion based upon the applicable law should be denied because there are genuine issues of material fact. And one further comment. On the issue of because he had excess, then anything he took constitutes a ratification or waiver. The citation given, at least one of them says that the court states a waiver has been defined as the intentional relinquishment or abandon of known rights. In this instance, and again, it's in testimony by my client, which raises the issues. Sorry, Your Honor, I'm at his office. Access to withdraw, to pay creditors, and to pay himself is not access to steal or to take money in excess of what was agreed to be taken. So we think that this is appropriately denied. This matter be set for trial. I put in there if there's some question about the clarity of the business relationship based upon their agreement, and that the actions asserted as wrongdoing stem from that disposes of the claim about the Fultz versus commercial union as being the applicable law in this instance. So we ask that the court deny the motion. Thank you.
I could just have 2 minutes to respond if necessary.
Sorry, counsel.
He made 3 arguments, basically, that it looks like a signature. It is. There's no contrary evidence. So you have to buy that it is his signature. He said it is. It is. He says we can't just take money. Again, we took the money that the contract says to take. There's no contrary argument, period. What invoice is not in accordance with the contract? We gave him all the invoices and we attached them. No contrary argument. Waiver, not allowed to steal. Again, we took what the contract says. No contrary argument. You can't just get up here and say something when you've admitted something in your deposition to the contrary, and you have no evidence after a year and 1 month after filing the complaint, and you don't say what invoice is wrong. We're done. This case is over other than the counterclaim. Unless you have any further questions, I have nothing further to state.
Okay. All right. Thank you. Again, I did review all the documents that were submitted prior to the hearing today. The arguments of counsel here on the record have been largely consistent with their written arguments. So I do feel comfortable in ruling from the bench on the motion. Again, the motion was brought pursuant to MCR 2.116C10, alleging that there's no genuine issue of material fact. Both sides correctly cited the court standard of review for motions under that court rule, and so I adopt those as indicated by the parties and apply that standard to the issue here. The first issue is whether or not plaintiffs have properly pled a claim here, which I think is really more properly a motion under C8, alleging that they failed to state a claim because their claims really sound in contract, not in breach of fiduciary duty or conversion, and because of the Fultz case and that doctrine that plaintiffs could not plead from a legal standpoint claims for torts where there's a contract that controls whether that's that written contract that Sitz alleges or whether some type of verbal agreement as Mr. Bergdorf is alleging on behalf of Spartan. So I really find that to be more of a legal issue than it is a factual issue and therefore more appropriate under C8. But regardless, I agree with Spartan and Bergdorf's argument that that doctrine does not apply in this case and that the Fultz case isn't really an applicable point of law that would prevent the plaintiffs from pleading claims for torts here. The Fultz holding and that separate and distinct claims doctrine holds that tort actions that are based on a contract where they're brought by a plaintiff who is not a party to that contract, that you can't bring tort claims guised as a contractual claim, breach of contract claim. I think the big difference here, and in reading the Fultz case and the other cases that discuss the separate and distinct doctrine, they are all cases of third parties bringing tort claims and not parties to the contract. And here, clearly, Mr. Bergdorf and Spartan were parties to the contract at issue. So I think that separates this from those separate and distinct doctrine cases and make them inapplicable. So I don't find that doctrine would bar the plaintiff's claims either from a legal or a factual standpoint. So I agree with Mr. Ingleson on that point. Looking though at this from a C10 standpoint, it's clear based on the First Amendment complaint that both plaintiff's claims are based on the argument or the position that SITS took money that it wasn't entitled to take under whatever agreement that they had. And I agree with Mr. Ingleson again that just because an agreement authorizes a party to withdraw money or take money for services, it doesn't give them carte blanche to take whatever they want. It has to be within the scope of that agreement. And so that's the argument here, is that what SITS did is outside the scope of whatever the agreement was between the parties, and that would constitute a breach of a fiduciary duty and conversion. Breach of a fiduciary duty requires the existence of a fiduciary duty, a breach of that duty, and of course damages. Statutory conversion requires that a party steals or embezzles funds, puts them to their own use, and that taking is a wrongful taking. And in order for the court to find that there's a question of fact as to either of those claims, they all have to flow, or they both have to flow really from some type of contractual relationship between Spartan and Bergdorf and SITS. A fiduciary duty had to arise from somewhere. It just didn't just exist by virtue of a past relationship between the parties or out of thin air. So it had to flow from some type of contractual relationship. Likewise, the conversion here, and the argument is that as part of the accounting duties that SITS took money it wasn't entitled to or hadn't earned. Again, for that to occur, there had to be some type of contractual relationship here. So even though I don't find that the separate and distinct doctrine applies, certainly the contractual relationship between the parties, again, whether that's verbal or pursuant to a written contract, is crucial and is really a threshold issue here, because the plaintiff's claims, regardless of how they're pled, those duties have to arise from somewhere. And in this case, the only place that they can arise is from some type of business agreement or relationship between the parties. And so any breach of fiduciary duty, any wrongful taking of funds here has to come from SITS not abiding by the terms of that agreement between the two of them. And so the court has to find either that there is a question of fact or not with regard to whether or not SITS went outside of the agreement, breached any kind of duty that he had that arose from that agreement. And so again, I think the plaintiff's ability to proceed with his two claims here has to come from showing and creating the question of fact that SITS did something outside of the scope of the agreement. And so again, one of the main arguments here is the defendants saying, look, we had a signed agreement, and I'm referring to the February 23rd, 2022 agreement. It sets forth all the terms that the parties are going to operate under explicitly in writing. Mr. Bergdorf signed that agreement in person. He's admitted that it's his signature. And there's based on the documentation and the invoices and so forth that were submitted, there's no question of fact that SITS abided by that agreement. And so when the court looks at what did the parties submit, and again, under a C10 motion, both sides, once one party supports their motion by documentary evidence, the other party has to bring forth documentary evidence establishing that there is a question of fact. And so when I look at what do we have here, what has been submitted in terms of documentation? Well, we do have what appears to be a signed and dated agreement with Mr. Bergdorf's actual signature on it. I read through Mr. Bergdorf's deposition, and he does acknowledge that that's his signature. He indicates that he doesn't recall signing that or entering into that written agreement. But looking at it on its face, it does appear to be a written contract between the parties. So does Mr. Bergdorf's denial through his testimony establish a question of fact as to whether or not he actually entered into that agreement? I think all other things being equal, maybe that's enough to create a question of fact. If you have one party testifying, hey, that's my signature, but I didn't sign this agreement. I don't remember signing it. That in and of itself, without any other evidence, could be enough to create a question of fact as to how that signature got there, whether it was actually part of that agreement or taken from somewhere else, photocopied on to it or some other way to make it appear as if that was the contract. But that's not what we have in this case. We have other surrounding circumstances, I think, that undermine the argument that he never actually signed that agreement. Number one, we have about 18 months of both parties following that agreement, nobody really questioning it. Certainly no documentary evidence has been brought forth by Spartan or Bergdorf showing that somehow they contested what SITS was doing at any point prior to the October memo. So the fact that the parties proceeded under that agreement for a lengthy period of time indicates that Mr. Bergdorf did sign that and knew that that's what the agreement was between the parties. He does admit that it is his signature. As SITS pointed out in their brief, the October 6th of 2023 letter, and this was discussed in Mr. Bergdorf's deposition as well, discusses, entering into a new contract or renewing a contract. Again, I think that lends credence to the position that Mr. Bergdorf was aware that there was an agreement in place. Looking at page 7 of 16 of that February 23rd written agreement, it does lay out all the amounts that were going to be charged. And all the invoices were consistent with the contractual language, which again shows that SITS was proceeding under the terms of that agreement for what I view to be a significant period of time following signing it. So I think all of those things together, again, seriously undermine the argument that although Mr. Bergdorf may not agree doing it, the argument that he didn't enter into that written agreement on February 23rd of 2022. And without any kind of documentary evidence and with only his testimony that he doesn't remember doing it, in light of all the other facts, the court finds that a reasonable jury would not be able to conclude that he didn't enter into that agreement. And so the court finds that there's no question of fact, material fact, that the parties entered into an agreement on February 23rd, 2022 for SITS to provide those services to Spartan and Bergdorf. Based on the documentary evidence submitted by SITS and the lack of any real documentary evidence contesting it, the court finds that during that period of time between February 23rd and October of 23, that SITS did proceed consistent with that agreement. I wasn't able to see any kind of documentation that amounts over and above or different from what was in the February 23rd document were taken by SITs. It appears to me, again, based on all the documentation that was submitted, that they proceeded, SITs proceeded with that written contract under the terms that were in writing, that there was no kind of objection to that or any dispute about what SITs was doing during that period of time, and that SITs did provide invoices, and all of those were consistent. So court finds that in addition, there is no question of material fact that what SITs did was within the scope of that agreement, that it didn't take funds that they weren't entitled to or weren't laid out in that agreement. And that regardless of whether the claims are based in tort or based in contract, there simply isn't any evidence that SITs breached any kind of duty or wrongfully took money, again, that they weren't supposed to take under the express terms of that agreement. So for all those reasons, the court finds that there is no question of material facts that as to the claims of breach of fiduciary duty and conversion, that SITs is entitled to summary disposition. And so under C10, so Mr. Weiss, the court would request that you prepare an order reflecting that ruling of the court and submit that for the 7th table.
I'll prepare the order and submit it. I'll pass it by Mr. Ingleson for his review before I file it if I can.
Okay, thank you. That's all that I have for today, and both parties are free to disconnect at this time.
Brenda, we had a status conference scheduled today too to, I think, set the trial for the counterclaim. I'm not sure if you still intend to, it was originally at 2 o'clock today, and I got an order moved to 11:15, so I don't know if you want to do it now or then or what.
No, I do see that. I'm sorry. I would like to set some dates for going forward. Mr. Ingleson, in terms of scheduling, is there anything that you would like to request going forward?
We're looking at a trial. Are you looking at a trial date, Your Honor?
Well, I don't know if we're at that point yet. You know, I don't know if you have motions that you would like to file with regard to the counterclaims. I don't have a problem if Mr. Weiss wants to get trial dates set, but I would like to build in time to the extent that there's further motion practice.
Well, why don't we do that? Put in a time for dispositive motions. And if the court wants a, final pretrial settlement date, that's fine with me. And then whether you set the trial today or at that point in time, of course, is your prerogative, Your Honor.
All right, and then I guess my other question, I'll direct this to both counsel. There was mediation, correct?
Yes, there was, Your Honor.
Yes.
Okay, and had the counterclaim been filed at that point? In other words, did the mediation involve all claims between all parties?
It did.
Yes. Yes, Your Honor.
Do either of you feel that additional mediation would be fruitful given the court's ruling today and the way where things are going to stand at this point?
Well, my perception on behalf of my clients is that Mr. Weiss and I have been at this long enough that I'd be happy to engage a mediator again, but I don't know that it's necessary because we're certainly able and have been able to communicate back and forth.
I agree with that. Mr. Inglis and I have been able to talk through this entire matter as professionals, and I don't see any reason why that should end now. So if we have any basis to do so, we can certainly continue to have conversations. We even had conversations pending the outcome of this motion too, or before the motion was heard. So we will continue to have those conversations, Your Honor, I can assure you.
All right, then I'm not going to require the parties to spend further funds in pursuing mediation outside of just informal negotiations between the two of you. So, Mr. Weiss, then I'll ask you, was there a jury demand in this case, or is this going to be bench trial?
I think Mr. Ingleson did have a jury demand. I don't.
True. I'm sorry.
Okay.
We did file a jury demand, Your Honor. I don't know one way or the other. I'll stipulate if he says he did, he did. If he didn't, he didn't. It's in the file, so.
Yeah. All right. Are both of you want to rely on that going forward?
Yes.
Okay. So Mr. Weiss, for your claims, how much time do you think we would need to set aside for trial?
1 day tops.
Mr. Ingleson?
Well, with a jury trial, Your Honor, I see it as a 2-day event.
That would be fine too.
You know, would it be
I'm not gonna argue
longer?
against that.
We'd hope not, but
Okay. Mr. Weiss, if you can, I don't want to have everybody stepping on each other here, so I know it's hard on video sometimes to have a conversation, but you can not talk when Mr. Ingleson's talking so we can have a clear record, okay?
I'm sorry, I apologize.
That's all right, thank you. So we'll set it for a 2-day jury trial. I think that's prudent. Mr. Weiss, how much time between now and a trial date do you need to be ready to go?
1 month, but I do have a 1 month trial set to begin on October 6th in Oakland County. It's been adjourned twice, and I've been told by the judge that under no circumstances will be adjourned again. The only reason he adjourned it last time is because my opposing counsel had a stroke, which obviously was a very good reason to have an adjournment, and the court agreed. But they now have new counsel, and he said this case is going, so I can't do it in October. The earliest I could do it is in November, and I'd like to do it November, December, because I plan on retiring at the end of the year, and I'd love to finish this year and finish this case without anything hanging over me.
All right, Mr. Ingleson, as to that time frame, November, December?
those, either one would be fine, as long as we can, I don't know if we check with, your office for dates, but yeah, those 2 months would be all right.
Okay. All right, and then, Mr. Ingleson, I'll just set a cutoff date for any motions, any dispositive motions that you have for that they would need to be filed and heard no later than 30 days prior to the trial date.
All right.
And then I will set this for a conference immediately prior to the trial date, at least 14 days prior to the trial date, so that we can discuss witness and exhibit lists, the composition of the jury, and address any kind of procedural matters that we need to address prior to trial, so that once we get to the trial date, everybody's ready to go and we can just move right into jury selection and proofs. So the court will send out notice of the date of that final conference as well. Mr. Weiss, any other dates I can address for your side today?
I'm sorry, I didn't catch what you said. I apologize. Any other date? What?
Any other dates I can address for your side today?
No.
Okay, Mr. Ingleson?
Nothing else, Your Honor. Thank you.
Okay. All right, thank you. I've put all that into an order that'll go out to the parties, and that is all that we have for today. Both sides are free to disconnect.
All right, thank you.
Thank you very much, Your Honor.
All right, that concludes our morning docket. We'll be in recess until 1:30.